for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
Is this real life?
This is Radio Law Talk. And now, back to the show.
In 1968, a band called Spirit came out with a song called Taurus. And Taurus has this riff at the beginning that, and we all have had opinions that I think sounds fairly close to Stairway to Heaven at the beginning. And the guys in Stairway to Heaven did admit, or who, I don't know, I was at Jimmy Page. Jimmy Page admitted that he had their album and had listened to it before he did Stairway to Heaven. This is Taurus. Listen. This is the beginning of Taurus. This is 1968, very important. And then you have the Stairway to Heaven. To me, this sounds just like Stairway to Heaven in the beginning. Now,
it's
again,
missing some of the features.
Not exact, but it's a little. But here's the thing.
This is Stairway to Heaven.
Yeah.
The higher notes.
Well, that, and there's no background music. It's just an acoustic guitar for the most part with Stairway. Then the flutes come in.
You don't think they didn't hear that and go, wow. But here's the thing. All right, Cal, great. So here's the big issue is. The big issue is 1968. So we've talked about this on our show. You can go back and listen to our show about this on our podcast. But so it basically, the people from Taurus, the song Taurus, Spirit, it's their heirs that are bringing this lawsuit, because guess what? What did we say Stairway to Heaven has brought in? How many billions of dollars or hundreds of millions of dollars that it's brought in, that the value of this could be substantial? But so they lost the case, basically. It was thrown out, and the appellate court recently, the Ninth Circuit, right? It was the Ninth Circuit, I think, that revived it and brought it back. Now, this is what's happened. They revived it, and all they said is the jury can hear it. They didn't win. In other words, Taurus and Spirit, the Spirit, the band, and its representatives did not win. All they said is, yes, it can come back, and a jury can hear this.
And just to answer your question about how much money Stairway to Heaven has made, according to Quora.com, it's estimated that it's made $562 million since its release in 1971. By the way, I am wearing the T-shirt that commemorates the album that Stairway to Heaven was on.
Take a picture of that and tweet it out. We'll take a picture.
It was the fourth Led Zeppelin album. Now, here's some interesting things about the copyright, about the issue that was addressed by the court, because they did, all right, the band Spirit did indeed file for copyright protection and submitted paperwork for it, sheet music.
Yes.
The problem is the sheet music that they submitted did not include the intro that we have heard. It wasn't there, and so based upon the law, they said it couldn't be listened to. Now,
based upon the law from 1970.
From
1909.
From 1909,
right.
That was inapplicable at the time in 1971 when Stairway to Heaven was written. Now, the argument on appeal was this, that the appellate said, look, the attorneys for Spirit said, we don't want to play it so that the jury can determine similarity. We want to play it for a different reason. We want to play it so that the jury can observe the way Jimmy Page from Led Zeppelin responds when he hears it. And they had a couple of other reasons that they wanted it played that had nothing to do with saying, see, they sound alike, ergo, it's copyright infringement. And what the court said was, well, it was wrong for the lower court to immediately exclude it. There needed to be a 352 analysis, which is, would the jury more likely listen to that and then use it for the purpose they're not allowed to use it for, or the purpose that you wanted to propose it for? The long and short of it is it's going to go before the full Ninth Circuit to listen to it en banc to see if it is an issue. But the Department of Justice has now weighed in.
Well, stop. So the Ninth Circuit en banc, people don't, you got to explain
Sure.
what that is. So the Ninth Circuit, just 3 justices just heard it. It's basically a quick hearing. You want to hear it, but if all the justices hear it, that's what it sounds like it's going to happen. It may come out differently. But again, it's only has to do with, they don't win. Even if the Ninth Circuit says, yes, it's coming back, that just means it can go to a jury, and a jury can decide. But remember, the 1968 date, because in the early 1970s, they came out with the copyright laws that change that now allows you to listen to see if they sound the same, correct?
Yes, and that's the huge difference between the Led Zeppelin case and, say, Katy Perry that we talked about the last couple of weeks. Because in the Katy Perry case, as well as the Farrell case and the others, and Meatloaf would have been the same thing had it gone to trial. They'd be able to listen to the two songs and say, is it the same or not, right?
Right, and not have to just look at the music on paper to see whether or not it's the same.
Yes.
That's so the difference. It took a mathematical analysis out and put in a subjective artistic evaluation by the jury, basically.
Right. Now, look, one of the arguments about why the 1909 law the 1909 law is arguably discriminatory is because they said, look, this discriminates against musicians, against folks that don't know how to write sheet music. There are a lot of people that don't know how to do that they just know how to play. I mean, I've been playing guitar for 30 years. I really don't know how to write it all down. I just know how to play. And they cited, for example, Chuck Berry and others. And while I agree with that, I will make the argument that in those cases with a lot of those songs, the thing that made them unique was the lyrics, not the song. As an example, I will give you a clip from the movie Back to the Future. I want you to listen really specifically to what Marty McFly says to the band.
Watch me for the changes and try and keep up, okay?
Okay.
Listen to the blues riff and B. Watch me for the changes and try and keep up, okay?
So how does that apply?
Now, I got my audio coming back up here, so. All right, here we go. Now, here's how that applies. When he turned to the band and said, okay, this is a blues riff in B, keep up with me for the changes, every member of that band knew what to play based upon the statement, a blues riff in B. It is so common. Back then, the way these songs were written, it was a generally accepted rhythm, background. Everybody knew where to go in the chord changes. It goes from the first to the fourth to the fifth, back to the first, and that's the way it worked. It changed with the key. The only thing really unique was maybe the hook at the beginning that you heard and the lyrics.
And Marty McFly playing.
Yeah, and Marty McFly playing.
Right. All that, by the way, is fully explained in the song Hallelujah, where the first, the fourth, the fifth, the first, right?
Yes.
It's part of the lyric of that song, yeah.
Right, and a jazz riff is different than, say, a rock riff. And they have common ones in each genre, right?
Absolutely. If you go and study jazz, rock, blues, whatever, country, there's going to be – country's got like a nine sequence of 9 different things that they play in any given song, and all you have to do is tell folks where you start, and everybody knows how to play it. That's why they sound a lot alike. And so to come in and say, well, this should be unique and copyrighted based upon the way that it sounds, and it's discriminatory to people that didn't know how to write music. Well, the music all sounded a lot alike at the time anyway. And so I don't know that necessarily holds water. I'll be interested to see what the Ninth Circuit and Bank does. That's the whole Ninth Circuit.
Well, tell us what the government's doing. The key is the government has stepped in, and don't forget there's a thing, Denise, that the government can file their own brief. What's it called?
Amicus.
Yep.
Or an amicus.
Amicus
brief.
Amicus.
And that's what the Attorney General did in this case. He filed and said that we're erring on the side of Led Zeppelin, that we believe that Led Zeppelin should prevail, and that's because of the interaction between the 1909 Copyright Act and the new 1970 Copyright Act.
Right.
So because Spirit falls under the 1909 Act, and Led Zeppelin falls under the 1970 Act, and when they did their Stairway to Heaven, they actually got the beginning of the song as part of their copyright. That's Led Zeppelin, arguably. The
standard also under the old version of the law is that the two had to be virtually identical. And the government is saying here that there's enough variation between these two that if you send it back, there's no reasonable jury would be able to say that they are virtually identical. Therefore, don't send it back. Just let it take care of them.
So the standard under the 70s Copyright Act is substantially similar and can cause some kind of confusion.
That's right.
Those are the two different standards.
So that's going to take us into the end of our first hour.
Go to the website
RadioLawTalk.com. That's RadioLawTalk.com.